Welcome everyone to this Privacy Rules, Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And today I'm joined by Kim Walker from the law firm Shakespeare Martineau based in UK. And Kim is an expert in data protection and privacy. And today we are going to discuss together with him about the recent UK government's data protection reform. So Kim, first of all, thanks a lot for being with us today. And my first question for you would be, why is this reform taking place?
Well, the reform is a response to a consultation of the UK government now that it has the power to depart from the GDPR rules following Brexit. It wanted to look at whether it could reduce some of the burdens on businesses. And it issued a consultation paper last year, I think in September, and the results have just been published and the government's response has been published. And indeed, a data protection and digital information bill, which is the draft legislation, was published only 2 days ago on the 19th of July. It only affects UK GDPR, so it only affects the processing of personal data of people in the UK. It doesn't change, and indeed, of course, the government has no power to change the EU GDPR. And I should also emphasize that these are just proposals at the moment, but it looks as though that something like this will go ahead.
Of course, and thanks a lot for giving us this quick overview on these. And what does the proposal involve?
Well, there are a number of sort of fairly detailed proposals. First of all, I should say probably that the proposals are probably less radical and more conservative than many people thought they would be. That's probably partly because the government doesn't want, of course, to lose the UK's adequacy decision from the EU, and also because it's realised following consultation that the GDPR isn't quite as troublesome as perhaps politicians think in the UK. But it has made some fairly fundamental proposals. For example, it will remove the requirement to have a data protection officer. In the UK, you will have to have a senior responsible individual, but all the requirements that exist for data protection officers relating to independence will fall away. So that'll be much less burdensome, because trying to find a data protection officer is actually quite difficult. It'll remove the requirement to have a ROPA, a record of processing activities, or even to conduct data protection impact assessments. Both those requirements will be replaced by sort of looser, more flexible requirements, more risk-based requirements. So you'll still be required to keep processing records, but not in a particular form. And you will still be required to carry out risk assessments, but in appropriate cases and based on the particular circumstances. So the requirements are much looser and less prescriptive than the GDPR. There's going to be a white list of legitimate interests where the government will say you don't need to carry out a legitimate interest assessment because it's obvious that it's legitimate interest. For example, some things that are clearly in the public interest, child safeguarding, all those kinds of things, and the list can be added to. So ideally, there should be fewer requirements to have to document assessments in cases where it's actually perfectly obvious that the legitimate interest applies. And one of the big changes, I think, is the government's view on cookies. Ultimately, they've said they want to remove the need for opt-in consents. They're going to remove the need for cookie banners, these pop-ups that annoy everybody. Initially, they'll say you don't need to get consent for certain non-intrusive cookies, such as analytics and so on. So if those are the only cookies you collect, you don't need a consent. And ultimately, they intend to get rid of cookie banners entirely by allowing users to rely on adjusting their browser settings and things. And I think that's quite interesting because it's quite a departure, quite a difference from the way other regulators are looking at cookies. I mean, around Europe, they're clamping down, I think, on cookie consents, whereas in the UK we seem to be loosening the rules.
That's extremely interesting, Kim, and thanks a lot for this. It's quite clear that it looks like that the path that UK is taking is to make life a bit simpler, let's say, for UK companies in comparison to the GDPR. So also under this point of view, I see a lot of advantages probably in this approach, but are there advantages but also disadvantages, and which are those for companies in the UK in particular?
Well, there are risks. There are risks, for example, the government has said it doesn't want to reduce the standards of data protection for individuals. But obviously, if you don't have a data protection officer, there are some less prescriptive internal governance requirements for how companies look after data. There are less prescriptive rules on risk assessments and so on. Then there is a risk that standards will slip, and indeed the privacy campaigners in the UK are concerned about that. The other risk is to the UK's adequacy decision, because one of the other things the government has done in this proposal is to give it more flexibility in granting adequacy decisions to other countries that the EU hasn't yet granted adequacy to. It's going to take a much more flexible, much more risk-based approach to assessing adequacy, much less based around essential equivalence and strict rules like that. And there is a risk that the EU will say, when the UK's adequacy decision comes to be reviewed in a few years' time, that standards of control of cross-border data transfers in the UK aren't sufficient. I mean, I must say at the moment, there aren't any signs that will be the case. The government just wants to have a little bit more flexibility to enable it to speed up the process of granting adequacy, and also look for other ways of cross-border data transfer, so allowing certification schemes, between particular companies or between particular business sectors or within business sectors. So I'm fairly positive about that kind of thing. And indeed, the European Data Protection Board has commented, or a member of the board has commented, that there are a number of things in these proposals which the EU will probably consider when the EU GDPR comes up for review in I think about 2025. So I think some of it is quite positive, and I think this is also quite important, is that it will result, of course, in there being two different regimes, depending on whether you're talking about UK data or EU data. And for many businesses, that it will be great having all these relaxed requirements. It will reduce costs of compliance, legal fees, and so on. But for companies and businesses that trade both in the UK and in the EU, they may say, what's the point of trying to comply with two separate regimes? We'll just comply with the EU GDPR, as we now do, and not worry about these more relaxed requirements in the UK. So for some companies, these reforms will have little impact.
Perfect. Wonderful, Kim. Thanks a lot for this. Yeah, I think that the very positive news is about this positivity, let's say, among ADPB, EU institution, and UK experts, as you are, on the fact that there may be fine-tuning between UK and the EU, avoiding a situation like the one we are witnessing today between the EU and the US, that is making life quite complicated for EU companies in particular, and that's a very nice thing to hear. Of course, then it will be probably on UK-based companies to decide, which approach to use, following GDPR in order to stick within the stricter regulation, or to find, some sort of double approach. But it's nice that they can decide at least. So that's a good thing.
The big test will come when the UK enters into some sort of deal with the US for data transfer, a sort of privacy shield 3. Will that be acceptable to the EU authorities? Will that be acceptable to Mr. Schrems? All these things, lots of fun and games ahead, I think.
Absolutely, and that were very good questions, and it will be interesting to study and know more about this interesting triangle between US, UK, and EU, and of course involving also other countries in the near future. We are ending up of our time, but Kim, thanks a lot for this quick introduction and explanation of what's happening in the UK. We look forward to have other espressos to know more about next steps on this very interesting topic. So I would like also to thank our listeners for being with us today, and thanks again, Kim, and see you all next week. Bye everyone, and bye, Kim.